I'm going to be picking up where the judge left off and talking about privacy specifically. It's a buzzword in our contemporary society, but it's always actually been at the core of our Constitution and the processes of constitutional decision making. There are many people who think that it was the impetus behind the Bill of Rights, the first 10 amendments. And in 1890, there was an article written by Louis Brandeis and Sam Warren called On Privacy. And so this is from 1890. Instantaneous photographs and newspapers enterprises have invaded the sacred precincts of private and domestic life, and numerous mechanical devices threaten to make good the prediction that what is whispered in the closet shall be proclaimed from the housetops. So this concern from 120 years ago is not gone today, obviously. It is at the root of much of the debate about searches and data privacy and personal privacy. Generally, there are described to be three forms of privacy. The first category of bodily autonomy or bodily privacy concerns issues generally around forced medical treatment and other bodily intrusive things like reproductive choices. So, for example, in the 1940s, a case called Skinner versus Oklahoma, the court held unconstitutional the forced sterilization as a punishment for a crime. Griswold versus Connecticut, which was in the 60s, that evolved into saying that it was unconstitutional to criminalize the use of contraception. Now, over the course of the years, those bodily issues have morphed into whether to refuse medical treatment, as I said, the debate currently about dying with dignity, choosing to withdraw medical treatment, for example, and of course the right about whether or not women have the right to terminate non-viable pregnancies is also part of this debate. There was a recent case that I'll just mention briefly that pulls into this theme, and it was called the Florence Board of Chosen Freeholders, and that case actually retreats from a right of bodily autonomy. It's about a strip search in a jail. It's actually a remarkable case. The court decided it last year, where the question was in that case whether if you're arrested, even falsely arrested, and put into a general population in jail, whether you can be strip searched as part of that temporary detention. And the court said, yes, you can be strip searched if you're going to be put in temporary detention. And what made that case remarkable is the person who was being put in temporary detention was being pulled over for a traffic violation, and the state law at issue just said you have to put him in general detention, that you strip search as part of general detention for safety reasons, and it doesn't matter whether there's probable cause or to find you dangerous or not. So the issue of being free from intrusions like that was reduced, people say, in that case. There's also the spatial right to privacy, and as the judge mentioned, your home is your castle. The home is where you have most privacy, or at least that's what has always been the case in constitutional jurisprudence. And it is extended at some part to your car as well. You have the right not to be searched unreasonably in your home and sometimes also in your car. The U.S. versus Jones case puts pressure on what a search is. And is the physical trespass what constitutes the search? Or is it this 24/7 electronic surveillance, which is unreasonable? The last form of privacy is what I talked about as informational privacy, which this 1890 quote brings us back to. And here I'm not sure how the cases are going to come out, but I'll tell you where they have gone. Generally speaking, with information privacy, the countervailing interest is the First Amendment, the freedom to know truthful information and to disseminate truthful information. And so what the court has generally been is very unprotective of individual informational privacy as compared to public speech rights. So speaking truth about someone, even if it's a nasty truth, is not going to subject you to defamation liability, for example. Likewise, false statements about you without proof of actual injury to your reputation will not subject you to liability. The First Amendment protects that. Now, where this is going to break out is when we disclose our confidential information every day when we do a search online. That information is given to big data. It's given to Google, it's given to Yahoo, it's given to Microsoft. When we type in something on our phone and it stores that information and Verizon or AT&T or whoever it is collects that data, are we waiving our rights to that informational privacy about that information when we give it to a third party, such that it is free to be shared, so we don't have a reasonable expectation of privacy in that information? Which is it? When we search online, is that privacy that is protected from a search without a warrant? Or is it like going out in public and doing things that can be viewed? And I'm going to guess that the court is probably, at least initially, going to say government intrusions on data might be held to a higher standard. But when we give that data to a third party, even, for example, in a Google search, that may be a form of waiver and diminish our privacy because our reasonable expectations are evolving with the times, and privacy is measured in part by what we do and what we expect.